Welcome to our VIVOS Roundtable on Digital Assets, Regulation, Security, and Cross-Border Challenges.
It is complex. I mean, even the starting point of trying to structure your business is already an academic exercise.
The nature of crypto assets, the fact that it's easily traded or moved, across jurisdictions, and the fact that it's anonymous.
So that's something we need to be careful on. But why the crypto scams or fraud, you can say, a lot more prevalent?
Meet V. Kumar Sharma, partner at Eldon Law, leading digital assets and cybersecurity. Next, we have Michael Liu, quantum security leader and co-founder of Aegis Digital Asia. At last, we have Amelia Tan, counsel at Carey Olsen, expert in cross-border disputes. Together, we're going to uncover the future of digital assets, regulation, and security.
Good morning, everyone, and welcome today to our VIVOS Roundtable on all things digital assets, from regulation, security, to what to do in those oh no moments. Today's conversation hopes to bring together three leaders who operate right at the intersection of law, technology, and security. From regulatory structuring and asset recovery to cybersecurity, forensic intelligence, and cross-border complex litigation. This panel has handled some of the most high-stakes cases in the digital asset space. Let me briefly introduce our speakers. First, Amelia Tan, counsel at Carey Olsen Singapore, specializing in litigation, fraud, asset tracing, and cross-border insolvency. With deep experience across BVI, Cayman, and Bermuda, she frequently advises on digital asset disputes, freezing orders, and complex recovery actions across jurisdictions. Second, V. Kumar Sharma, partner at Eldon Law LLP, where he leads the digital assets, cybersecurity, and emerging technologies practice. His work spans regulatory advisory, token structuring, commercial fraud, and recovery of misappropriated digital assets, with recent recognition as a Singapore Rising Star by Asian Legal Business. Last but not least, Michael Liu is a seasoned expert in digital forensics, crypto investigations, and quantum security. He's the co-founder of Aegis Digital Asia and previously served as CEO of Raja and Tan Technologies after his AI-driven legal tech startup was acquired. He's also a court-recognized expert witness and chair of the Blockchain Association Singapore's Digital Enterprise Subcommittee. Over the next hour, we'll explore where legal frameworks are adapting, where security blind spots still exist, and how businesses, investors, and policymakers can better safeguard this fast-moving ecosystem. So let's dive in, starting with how the regulatory landscape is keeping pace with the rapid innovation we're seeing in tokenization, DeFi, and beyond.
Thanks so much, Ray, Ivan, for having us here today. I think this is a really important topic, both in terms of what can be done in this jurisdiction today and the challenges that faces everyone, right, that's trying to operate in this industry. So, I mean, broadly speaking, in Singapore, we've had the Securities and Futures Act. And the primary question that arises out of that statute is whether or not the token that you are, or the service and token that you're providing amounts to a capital markets product, whether or not it's a security token or utility token. That's the primary threshold question. Singapore has evolved. A couple of years ago, 2019, we've got the Payment Services Act that regulates activity. And the threshold question there is whether or not the token that you are dealing with broadly is a digital payment token. And of course, there are questions around how that's defined and recognized exceptions as well as to what is not a digital payment token that certain projects rely on to carry out their operations. Third, and most recently, we've seen this omnibus regulation, the FSMA, Financial Services Market Act. I don't have the full name off the top of my head, but it's abbreviated as the FSMA. And of course, there was this recent concern when MAS issued this 30-day deadline for businesses operating in Singapore to get a license if you're providing a digital payment token services to customers outside of Singapore. So if you've got a Singapore HQ and you're still providing services overseas, then you need a license, right? And if you don't have a license, you're not allowed to operate. So there was quite a fair bit of controversy there. And well, long story short, there are certain exceptions to that particular regulation as well that our clients have relied on. The primary one being that you are a technical services provider, right? So there are two threshold questions when it comes to whether or not you want to get licensed and you don't want to get licensed but still operate here. If you don't want to get licensed and still operate here, then first we could have arguments about how your services doesn't involve a digital payment token, so that those regulations may not be triggered. But the second one, and the one that I think is the better one, is to rely on the express exceptions. And being a technical service provider is one of them. So how we see businesses structured is that Singapore will be the technical services provider. Maybe we'll park the intellectual property here. Funds may also be raised on the Singapore entity. At the same time, the actual token generating entity may be somewhere else, right? Usually the tokens are generated in an offshore jurisdiction. Amelia will have plenty of experience with that, no doubt. But we've also seen Abu Dhabi, the ADGM DLT Foundation, Distributed Ledger Token Foundation, being a choice for some businesses. And I think the value there is that in some instances, it's an orphan entity. And when I say orphan entity, I mean that you can set out the beneficiaries and you can have no shareholders in that entity. So that gives businesses more ways to argue that there's no nexus between the Singapore entity and the Abu Dhabi entity, right? Because you can change control, you can have different management teams, they're different owners. So there is that gap, right? And you can hedge your risk with contracts, etc. And of course, finally, in this structure, there will be a front-facing entity which actually carries out the service. And depending on the type of business you're doing and the jurisdiction in which you're doing it, you may need a license. But you may not need a license in Singapore, right? So we've seen front-facing, for example, DEXs, decentralized exchanges, seeking licenses out of the BVI, for example. So broadly speaking, that's how we see businesses structure themselves to meet their objectives, whether or not they want a license, where they want to do it, and whether or not they want to stay in Singapore and still operate, leverage on that, the resources and branding that comes with operating out of Singapore. Yeah, but I think I shared quite a fair bit. Amelia, I'm grateful for any thoughts you might have on what you've seen in the space.
Yeah, I mean, thanks for sharing that, Kumar. I mean, it's interesting to hear how Singapore has evolved in terms of catering to businesses who want to have some sort of presence here, but also the cross-border element, which is kind of synonymous with crypto assets and how the crypto the business is operated. So I think well, I can speak from an offshore perspective. So, in BVI and Cayman, because it's what we do at Carrier Olsen. And I think in terms of the regulatory framework in the offshore jurisdictions, particularly BVI Cayman, I think in terms of regulating the digital assets environment, a fair bit of thought has gone into that. And in fact, I think BVI Cayman is one of the first few jurisdictions to have actually come together to put together some sort of framework as early on as in 2015 to have consultations with the relevant players. And eventually that gave rise to the Virtual Assets Providers Act, or in short, VAPS, which I'm sure you've heard a lot about. Essentially, what it is a framework that aims to give enough control, supervision of virtual asset service providers, and also sort of supervising all the activity that's going on in that space. But of course, that being said, I think the framework is there to give a good sense of what is required in terms of licenses, but at the same time, it doesn't stifle. The aim is not to stifle sort of crypto activities, be it exchanges, issuers, and I think the whole idea of BVI Cayman is really sort of to encourage players to continue to operate out and have certain businesses in BVI Cayman. And in fact, we'll touch on that, I'm sure, at a later part of the the session, you'll see actually, when it comes to asset tracing and recovery of stolen tokens or tokens that have been misappropriated. Very often, you do see an offshore entity there, and we have been advising in terms of strategies and ways that one could help and to help recover these lost tokens. And I think while you look at it a whole spectrum, right, from the start, initial regulation to things you can do later on to help recover tokens. I think the offshore jurisdiction has a good framework in terms of legal protection from start to the end.
Thank you both. Really fascinating. And if you think of all those different legal jurisdictions and the flow of funds and the cross-border nature, do what kind of legal challenges, what kind of legal obstacles does the multi-jurisdiction, the differences in legal treatment across the jurisdictions pose? So someone wanting to get into this space, what kind of advice would you give them to keep it simple, to consider the legal risks and the legal considerations from the beginning?
I think because I hesitate because I can't think of a simple sort of like just do it one way and you're golden, because it is complex. I mean, even the starting point of trying to structure your business is already an academic sort of exercise, in trying to figure out what you're doing, where you're operating from, and more importantly, how you're going to raise value, on your business, whether or not it's being done on the equity level or on the token level, and how that's structured. So I'm sorry, man, Ivan, I don't have a simple sort of do it out of Singapore and in your gold. The truth is that you have to constantly keep your eye on the ball because the laws are constantly changing. There are constant challenges in this industry, both in terms of how the industry is evolving. So we've got industry trends, right? We've got real world asset tokenization as one of the next things, next streams that people are trying to build. And at the same time, you've got evolving regulations. So I don't think that there's unfortunately, a simple solution. And my advice, and I'm sure Emilio will agree with me, is that you have to keep your eye on the ball and constantly reassess your business, both in terms of whether or not it's playing within the right boundaries and the steps you're taking to protect your assets and protect the business.
Yeah, I agree with all of that. I think the nature of crypto assets, the fact that it's easily traded or moved across jurisdictions, and the fact that it's anonymous and it's done very quickly. All these are challenges. If you are going to this space, that's challenges that you have to deal with, you have to grapple with. But like Kumar said, you just gotta be aware on developments, and know that the legal framework is also developing at the same time, right, to help you, be it regulations at the outset or even asset tracing mechanisms, things that you can do if something goes wrong, but hopefully we won't get there. But yeah, I mean, it's as with every new industry, there are challenges. It's sort of understanding the fundamentals, the principles, and understanding the system, the ecosystem that you're sort of dealing with.
Okay. So it's constantly evolving. It's wise to keep up to date, get the latest advice, but it's also partly what you're trying to optimize for, right? What are your objectives? What are your goals? And then depending on that, there are good solutions. You've both kind of touched on it a little bit, but then what are the areas that you think Singapore plays a role, or where is Singapore's strength in this architecture then, or this model? What's Singapore good at?
Singapore's primary strength is its reputation, first of all, in terms of being a jurisdiction in which it's stable, there's stability, there's some level of certainty, right, with how you can structure and operate here. And I think that's of tremendous value, operating out of Singapore. What was the second part of your question, Ivan? Was there anything else on it? Or just why Singapore, was it?
Yeah, you covered it well, I think. Amelia, what are your thoughts?
I mean, I obviously I'm not one to best place on advice on what Singapore is doing. I mean, on the crypto front, I mean, I don't advise on Singapore laws, but from what I know, of course, Singapore is very competitive in terms of sort of regulations, and also encouraging players to want to operate out of Singapore. And I think that's evident from, you look at the big crypto exchanges that have issues, or rather the big players have gone into the ones that you hear about more commonly, right? Like 3AC, and all of that. That there is a Singapore element. So by that on its own, you could tell that Singapore has sort of already managed to attract very big volume, high value sort of crypto businesses to operate out of Singapore. And I think the fact that we have seen disputes early on just shows that Singapore can only get better in terms of sort of strengthening the framework, improving the sort of the regulatory environment to.
Between the experts here, what are your thoughts in terms of the different strengths and weaknesses of the legal jurisdictions and the major locations that are active in this space globally at the moment? Amelia, would you like to share anything? You've got a good perspective across some of the key locations.
Yeah, I think in terms of the jurisdictions that I deal with, so offshore jurisdictions, BVI, Cayman, it helps that the courts there, the regulators there, are very used to dealing with not a lot of information about end users. It's only a very recent, or not that recent, but I mean a couple of years ago, where information on directors are publicly searchable for BVI Cayman companies. So regulators, courts are well equipped to deal with these sort of issues, which we now see in crypto assets, where this anonymous transacting of in terms of transactions, not knowing who are the holders of private keys, wallets that have no owners. So things like that are I think issues that are not new to offshore courts. Obviously, in terms of the kind of assets you're dealing with is a different nature, it's a newer class of assets. But I think general principle wise, you will see a lot of similarities in terms of how the legal framework are used or adapted to help in asset tracing efforts. So from that perspective, I think the offshore jurisdictions has sort of a good head start, in the sense that it's not something new. It's something they've been grappling all the time. In fact, the courts have always been sort of at the forefront of dealing with not so clear issues of laws, and they're not shy of pushing boundaries and making sort of new decisions if they have to. And I think we see that in a couple of crypto decisions where, I think shortly after the UK decision, where an injunction was granted against persons unknown, the judgment was also made in a BVI to that similar effect. So, things are moving very quickly, I would say, in BVI, keeping up to help in asset recovery efforts for stolen or misappropriated crypto assets.
And Kumar, thank you, Amelia. Kumar, your thoughts?
Well, I think it's established that cryptocurrencies are property, right? And now we've got cases talking about what type of property. And the type of property that a crypto asset has a bearing on how you build in protections at the start. So I'll give you an example, right? There's a High Court decision right now which observes that crypto assets are a chose in action. What does that mean? Right? A chose in action is a right that you have that you can use in court. It's not something physical. It's something that the court recognizes as valid and can be protected. Think of your right as a shareholder, your right to a debt in a contract. That sort of incorporeal right is what a crypto asset currently is characterized as in Singapore. In the UK, there's a slightly different approach. In the UK, there's a judicial task force that has proposed a third category of object called digital objects. And the primary question there is of control. Who controls that object? Now, I I personally, this is my personal view, I actually like the UK characterization a little bit more because it gives clarity on two aspects. If I call this asset a digital object and I give that asset away, let's say I give some to a market maker, how do I retain control? I can argue that it's being held on trust. So if anything happens to that third party, it goes insolvent, it's still your asset. The second is retention of title. There are all these concepts about traditional commodities trading that could apply to crypto assets if they are characterized as digital objects that would apply. So, notwithstanding who possesses the object, as long as title is yours, it's your asset. Right? So, those are the types of things that I actually want to see, and I try to build into contracts when people are dealing with assets and lending them out. Whether or not you retain title, assuming, of course, the law recognizes it as an object, and second, holding it on trust. Those are two common areas. But yeah, that's where we're at, right? What type of object? The next part of this conversation will be taking security over that object. So you've got all these charges, pledges, all these old, not old, but in traditional industries, you've got other ways of taking security over assets. That will start to apply and has already begun applying to crypto assets, and we'll start seeing more of that as the industry evolves.
Michael, thank you, Kumar. Michael, what are your thoughts?
Yeah, so I want to talk about sort of KYC, right? Know your customer. So in that sense, I think that has evolved as well, because traditionally the customer of a digital asset is usually an individual, you know. So even you're talking about startups, you know, it's still an individual holding a wallet, you know. But we have seen a change. There's a lot of institutional purchaser as well. So when it comes to corporation, even Listco, sort of accumulating crypto asset, right? So when it comes to organization, then it will be a different safeguard because it will not be held by the CEO or individual, you know. So there are policies and procedures. There's also third-party service providers like custody services. So I think that is a major shift that we are seeing, and that also means that the industry is evolving. You know, so once you get the sort of commercial or corporate clients in, definitely it is a good sign that it's heading more commercialized direction. Yeah.
Thank you, Michael. And we touched a little bit earlier on things like tokenization of real world assets and the different types of use cases. So just curious from the three of yourselves active in this space, what are the kind of emerging types of crypto securities, crypto's assets, crypto projects that you see taking off, particularly in relation to Singapore and this market here?
Yeah, maybe I'll start first. I think in the recent sort of months, I think there is a big move to use of stablecoin because the thesis of using sort of crypto asset has been quite sound. But of course, the problem with crypto assets such as Bitcoin or Ethereum, you know, it does fluctuate, you know. So, but again, in the commercial aspect, you know, if the adoption from corporate, so they will want something which is a bit more stable. So in that sense, the use of stablecoin for their commercial purposes will be much welcome. How about the rest? What do you all think?
Well, I can't speak for Singapore specific projects. I mean, I know that there are DeFi projects. Some DEXs, one DEX is operating in a sandbox, but I can say that as a trend, right? There's agentic AI, so the intersection between AI and blockchain, right? The sort of projects where you own a piece of the AI and you're able to trade it on chain. That sort of project, we've seen some of that. We've also seen securities related tokenization of securities. So we've seen projects that try to partner up with registered securities brokers and design the entire onboarding and payouts for bonds, for example, on chain. So we've seen a few projects trying to put your securities investments on chain. I could put it that way, right? And how do you go about structuring that? Those are the two big trends that we've personally observed. How about you, Amelia? How about your end?
Yeah, I mean, I think broadly speaking, they kind of mirror what I think both you and Michael have been saying. But I think there are also other things like sort of uses of digital assets in which how we can encourage more prevalent use of it. So like you said, securitization of that is a big one. The use of it in sort of payment for services, I think, as well, in terms of offshore jurisdictions. That is something that has come out in recent years for discussion. I don't think it's Cayman BDI specific. I think it's what is happening generally across jurisdictions and markets.
Mm.
How about another type of trend? Trends about scams and frauds and illegal activities. What do you guys see in the market right now? What's the latest trend in terms of scams and fraud for digital assets?
Yeah, that's a very interesting topic for me because I do see a lot of sort of scams and fraud around crypto asset. So, but the observation is nothing new. It's all about greed. It's all about the positioning. So scam remains scam. So what is different is because there's a huge interest in digital asset, especially in Bitcoin and some of the other performing digital currency. So they are using it as a leverage. So again, it rides on greed. So to make quick money, with very little effort. So that's something we need to be careful on. But why the crypto scams or fraud you can say a lot more prevalent is because a lot of people don't understand that it's not like your fiat currency. Because in fiat, you will still have to have a bank account. There's financial institution. They're all regulated. So you can trace back who you sent the money to, right? But when it comes to digital asset, with just a crypto account, that's very, very difficult to trace where it comes from and where it's going. So that's something you need to understand. And again, to safeguard your own digital wallet, it is also very difficult if you're not savvy enough. Even the more savvy sort of cybersecurity professionals like ourselves, we do struggle as well because there's a lot of hack. There's a lot of cyber threat out there. That even the larger organizations sometimes they felt there's a challenge. So the little guys like us, we try our best. But you need a lot of safeguard. If you're putting all your eggs in one basket, in this case, it's a sort of digital wallet, then you need to know how to protect it.
Yeah. Yeah. Dr. Kumar.
So
Thank you,
this
Michael.
topic, all three of us here is very close to us because we see the effect. We experience the effect vicariously of all these of everyone who suffered these losses, and we find it. I mean, I'm always upset whenever I see someone get a loss, and we try our best to get a remedy. But in any event, back to the question, right? I think the majority of cases start with social engineering and phishing attacks. I've seen statistics about 50 to 60% of the attacks in the industry, right, is an attempt to socially engineer you from you basically departing possession of your assets from yourself, right? And the trend I see is that it starts off well. We've had phishing attacks in the past where funds are misdirected. So forget about crypto for a second. All these older industries where payment instructions are intercepted. So you're supposed to make payment, a third party impersonates the seller. Payment is made to the third party threat actor instead of the seller, right? And that entire compromise usually happens on email. Your email inboxes are compromised, email forwarding rules are set up, and then you have to deal with the effect of having to pay twice, once to the hacker, once to the actual person who's entitled to payment. Then we've seen a shift to more hacks on crypto assets, but a large majority of it also starts to some extent, right, with the same type of phishing attack, where you gain access your monitoring systems, and then you are able to execute either a brute force attack or social engineering attack on these assets. And the third large trend is ransomware attacks, right, where you're locked out of your systems, and then the question becomes, do you pay or not? And once you pay, if that payment is made in crypto, then you have to start hunting down the crypto. But I think that, broadly speaking, when you're faced with an attack, you've got two options, broadly, right? The first is you go after the hacker. You can trace your asset, you could go and get your court relief, try and trace it to a centralized exchange, etc. But that's another approach, right? Which is you identify the intermediaries. So all of the third parties in between that contributed to your loss, those parties should also fork up a percentage. 30%, 40% of your loss should be attributed to them, for example. So for instance, if you were lost, you suffered a loss because you downloaded an app from a crypto trading app, and because of a compromise of their systems, you led to loss. Those guys are a target as well because you wouldn't have suffered a loss but for them. So a big part of what at least we are trying to do is build out this capability to go after intermediaries, whether or not they're trading parties, centralized exchanges. We've had some success negotiating with them as well. And the more challenging one, decentralized exchanges. That's another, those are targets. And I've got thoughts. We can talk about this all day, right? But third one, broadly, before I hand the mic over to Amelia. The third one is what I like to call the burn and remint remedy. So imagine someone takes your asset, you lose it, you call up the person who gave you the asset in the first place. That issuer, in some instances, can destroy the asset and give it back to you. Can destroy the asset in the hacker's wallet and just reissue it to you, a one-for-one exchange. So in my view, that must be the starting point in the entire analysis, right? If you suffer a loss, you should be able to go to the issuer and say, if your timing is right, if the right set of circumstances, do a one-for-one exchange. And we are seeing that now. I've identified at least 3 or 4 entities in public SEC listings which give investors this right to burn and remit. So you're slowly seeing this being adopted, and what we need this as an industry standard, in my view. Yeah, I've got other thoughts as well, but I'd like to give Amelia a chance to speak too.
Yeah, no, I think that's very interesting to hear, and especially in relation to what you said about the burn and reissuance sort of mechanism. I think that's not new because actually in the very early days, when crypto fraud, crypto misappropriation just became the hot topic. In fact, that's what we've been doing with VVI issuers. Some very often, these investors could be your mom and pops, right? So they are not very sophisticated. They may not want to spend a lot of money to trace complicated, tracing exercise. So they come to us and they'll be like, oh, I have this issue. My crypto assets have been misappropriated, or it could be that they simply lost control over their wallets. They just can't log in, or for some reason they can't access their assets. No, of course, then what we have done is we've gone to these issuers and said, look, this is an issue. Something has happened there. Can you please reissue tokens? And they actually, surprisingly, I mean, back then, there was a lot of uncertainty as to what it could do, but that was an option that they actually were agreeable to. And it happened pretty readily to a couple of issuers. So I certainly do agree with Kumar that is a convenient starting point, right? If they could simply, as a matter of a practical way of dealing it in terms of burning it, and just reissuing it, then that could be a cure to a lot of your very, I would say, your average crypto investor who may have sort of misappropriated, lost assets, or got scammed in one way or the other. But of course, you're talking about high value fraud. That's another question. And that, of course, requires a lot of technical expertise, a lot of tracing, a lot of finding out information as to how the transaction has evolved, from along the whole the whole blockchain, what has happened when it's gone past the exchange, and that's something that I think we've seen in the offshore jurisdictions as well. The hacks happen at the exchanges. The hacks has also occurred at the smart contract stage, where it sort of causes the payments to be transferred to someone else instead. So I would say it happens in all shapes and forms, and I think it's just going to keep evolving as well.
That's fascinating.
Amelia, there's no law, right? I mean, it's all goodwill at the moment.
Yeah. Yes.
Yeah. So I would like to add actually to summarize. So in the event, let's say there's a fraud incident or it's a cyber attack, or even scam, there's actually two recourse, right? So the first recourse is go after the perpetrator, right? So if there's a hacker or scammer, we'll try to go after that, but then that becomes criminal. So obviously you will have to involve the law enforcement to some capacity. So of course that's one track, but then I also hear from Kuma and Emilia, there's a second track, right? The second track is to work with the institutional, because there are people involved as well. There are exchanges, there are the issuers. So work with them to see how you can sort of stop uh, the transfer, because again, digital asset has its pro and cons. So the pro of it is not like physical cash. Once cash is flowed out, it's very difficult to get back. But in this case, it's still on the blockchain. So if you work with the right institution, the right parties, you could sort of put it what you call a no-win situation. The hackers could have taken your crypto, but they can't use it. It could be frozen or it could be reissued. So there's a recourse that, in these circumstances of digital asset that we should always consider, besides just going after the perpetrator. Yeah.
Yeah, this is very practical, helpful advice. And we talked about the different use cases, and I'm sure, Singapore is a massive asset management market, a massive wealth market. I'm sure there are more and more family offices, asset managers, investors out there who will have exposure, will be holding digital assets. And they will face these challenges at some point, possibly. So these three paths, or these two paths that you shared, what would be the practical advice, hour one, minute one, when you feel, oh my God, have I lost control? Have my assets been misappropriated? As experts, what would be your minute one, hour one action plan? What would you recommend somebody to do?
Evidence preservation is the first point of call. So you need to keep logs. Your Google Chrome web history actually sets out a useful chronology of how the attack broke out, where you went to, etc. Your email logs. Basically, the first point of call is retain evidence. That's very important because we've seen instances where businesses, they've got this automatic overriding rules in their inbox, and then you lose evidence after 4 months or 6 months, depending on how it's set up, and that may not be helpful. So I would say that's the first port of call. The second port of call, of course, is to call us, really, because at the end of the day, you need to go to the police, or you need to, if the police gives you enough information to say, okay, you've got some assets in these exchanges, then it might make sense for you to freeze, right? Get a freezing order, freeze those assets, and then trace your assets down so that you get some recovery. Some recovery is better than no recovery. Okay, and sometimes the economics of the situation, it makes sense for you to say, okay, I'll allocate this amount of resources, try and get that back, right? And of course, we can continue exploring how the attack broke out. So a key question that we always ask ourselves is, how does the threat actor know that you are a target? How does this actor know that your email address has got $4 million in a wallet on an exchange, right? And in our experience, it's either friends and family. Someone in your network told this is the person who initiated the attack. Second, your devices are compromised, probably from some other platform. Or the third one, and one that we've relied on successfully, is a data breach. There are some data breaches that your information is out there. If it originated from an exchange, for example, then you might have legs to pressure or negotiate with the exchange. Say, hey, this wouldn't have happened. This entire series of events wouldn't have happened, and but for that breach. And so, we should share that risk. It's about allocating that risk of that hack at the end of the day. So yeah, to sum it up, preserve evidence, and get in touch with the police and us, the experts, to see whether or not we can at least get something back.
Very interesting. I think not everybody would think of that preserving evidence aspect of it. And it's good to hear that there are examples where people can get funds back. So maybe we go into some case studies later. But Emilia, what would your advice be at that moment?
Yeah, I mean, I think both Kuma and I are litigators, and we're litigators. The first instinct that comes to you would be like, pause, right? Just don't do anything further. Keep whatever evidence you have, preserve it. Browser, that's obviously the key starting point. Just making sure you don't tamper with any evidence. Keep it, your search history and all that. That's going to be quite key. Then of course, it's really sort of a race against time, right? And how quickly you think um, you want to, basically, steps that you have to take to really try to freeze assets. Of course, there is a cost benefit analysis, how much we're talking about, and what are some of the options available to you. So I think speak with an advisor. It could be a technical advisor that will tell you like how you can actually practically go around tracing it, or a legal advisor in which we could tell you about what your immediate options are in terms of freezing. If not clear, it's not apparent to you who these third parties are, we could get knowledge pharmacal orders, against exchanges or issuers who may then be able to give you some information. It could be KYC information about certain people that have accessed your wallet, or and that might give you some inkling as to who may have been involved, and so you could know actually who to go against, and that's obviously the next stage in terms of framing your course of action, how to pursue, and whether the target defendants or respondents to any claim, can they actually, is there actually going to be any practical recovery if you were to commence any action.
So there's a couple of steps there, and wise to get good advice as soon as possible.
Yeah. Can I also add, I think, of course, I agree with Amelia and Kumar, data preservation is the key, but I think whenever there's an incident, right, don't make it a tech issue, it has to be a management issue, because I've seen many cases that the tech team took over because it's a cyber issue, it's a cyber attack to a certain extent, and then a knee-jerk reaction is they, in order to stop further spread, they will delete everything, or they will they'll get out of the system, So that's a very natural thought, but once you do that, actually you lose the linkage, you lose some very precious evidence to trace back, So it has to escalate to the top, the management, even the legal and compliance of the company. While they're not tech people, but they know how to manage, they know how to engage expert, and also I think the idea of data preservation is not something that I suppose the tech team are familiar with, whereas on the legal and compliance or senior management, they understand what that means, So that should always be the first step. Don't make it a tech issue, but more of a management decision on how to handle it. So they have to take over.
Interesting, Michael. And in your experience, that would be a tough decision to make if you have your lawyers telling you to preserve everything and your IT team telling you to delete everything. Is it your experience that the IT team are, it's wise to listen to your lawyers, or how would you weigh those up?
It is a balance. That's the beauty of it, right? There isn't a cookie cutter answer, So to a certain extent, both are right and both are wrong, right? So that's why engage experts, study the situation, and then see what works for the organization.
Okay.
In short, it's not so simple, right? Because it really depends, Of course, just to give a quick example, because in some instance, maybe a company has very good BCP, business continuity plan, right? So they have a lot of good backups and all those. Then you can pursue a more aggressive approach, to delete, to sort of cut. But if you don't have a backup, and then once you start deleting stuff, you'll never be able to recover the crucial information that your business needs to survive on.
Okay, so it's another consideration. A point you sort of touched upon, Amelia, and I think everyone mentioned, the economics of it, or the cost-benefit analysis. For an investor considering this, what are the kind of sums where it starts to be cost-effective to deploy this kind of forensic approach, this litigation approach, these injunction approach? At what point is the size of the asset usually sufficient that you're going to see a return on that kind of investment?
I think it's hard to give you a number, and ultimately it is for you to assess, right? I mean, it could be the very first. It could be that maybe this is your first fraud case. The value is not high, but maybe because, for example, your wallet, or whatever, is compromised. So there could be further recurrence of hacks into your wallets, and and all of that. So you might want to get to the bottom of it, even though the first incident may not be of substantial value. So I would say it's hard to put a monetary value to it. But of course, there would be fees involved in, obviously, getting legal advice, getting technical experts in to help you with the fact finding. And I think in courts these days, they actually do want to see some sort of depending on what the cause of action is, they might ask for expert reports as well, to trace the movement of the crypto assets. So you just got to bear all these in mind. But I would say, I mean, I don't know, Kumar may correct me if I'm wrong, but I think I think it's really hard to place a value to it. But I think you can expect, if you were to take legal action, that would cost you, at least, at the very least, thousands of dollars, even if preliminary analysis. So of course, if you're talking about really a small sum, then you may or may not want to do it. You may want to just approach the issuer and asking them to reissue the tokens to you. I mean, it's a self-help remedy. There's no harm in doing that, right? But of course, if you're talking about a huge sum and issue, then I would say get some legal advice. You may not need to go all the way, but at least you kind of know what your options are. Yeah.
Yeah, if I could quickly chime in before Kumar, I'm sure Kumar has a lot to share on this topic. In my experience, a lot of time it's not just the value of the incident, it's a lot on the reputation as well. So the reputation risk, and then also business disruption, because there are some cases that it actually disrupt the business. You have government contractors who refuse to work with you until they are certain that it's safe. So can you imagine the severity of the disruption?
Thank you, Michael. Thank you, Amelia.
I
Kumar.
mean, my thoughts are that, this economics idea is actually part of the attack. Death by 1,000 cuts. Seen it so often that the values that are being misappropriated are deliberately small. So you'll see certain threat actors deliberately taking small amounts so that the economics doesn't stack up against them and you can't pursue them. That's a very common tactic. And how to deal with that sort of approach is to raise a class action, right? So there's some instances where victims can band together if you're all part of the same scenario and pool resources to try and get recovery. That's how you deal with death by 1,000 cuts, right? In my view. The second one, I of course echo Amelia's sentiments in terms of costs, but my advice would be to spend that cost upfront on prevention. Right, so instead of spending it on your legal advisors later, there are two things that you could do. The first is don't self-custody, go to a professional custodian. Right, an institutional custodian can hold your treasury and your assets for you. That's certainly something that businesses must explore as the first line of defense. The second one is insurance, cyber insurance for theft, and if necessary, professional indemnity insurance. Right, so most custodians already have that insurance, but you must also explore whether or not you're entitled to it and can get insurance for your assets. Of course, an inadvertent side effect of having all these players around dealing with your assets is that, touch wood, if one day something happens to your assets, you have more people to look to for recovery because you have intermediaries who've got a role to play in protecting your asset as well. Right, so that's definitely part of the equation.
It's very interesting how the conversation is evolving, right? So you're not prescribing to the not your wallet, not your crypto kind of perspective on things, that trust nobody, control everything yourself. You think the market is evolving now with the larger quantums, larger values, that institutional players can be trusted to be your custodians, and they're more likely to have the firepower, the resources to be able to protect you, give you recourse, or go after the threat actor. So
absolutely,
in that sense, it's mirroring the traditional finance industry in a way.
Yeah, I mean, on just one last quick point on that, the term mirroring. So now, some digital asset custodians allow you to park your assets with them and also mirror it for example, on exchanges, so that you're actually trading a mirrored asset. So you save, you protect your asset, but you can still carry out business functions. That's certainly something that businesses have to explore, as your frontline defense against all of these attacks.
Michael, go on, continue.
Yeah, I think this echo what I shared earlier on, because we see that a lot of times the customer here are organization or institution, right? So it's no longer just an individual holding a crypto wallet. So there's a lot more options when you're an organization, you know.
Mm. And you mentioned, Kumar, the importance of preemptive protection rather than afterwards. So, what advice from a legal perspective, other than using a institutional custodian, is there other things that can be done to protect you from that
Absolutely.
perspective
Absolutely,
beforehand?
Ivan. The starting point is your contracts with all third parties. How do you allocate risk for your cyber attack? Where does the list fall? Are you going to characterize it as a force majeure event? Some people might, right? And then the chips lie where they fall. Or do you allocate risk such that both of you share 50-50 if something happens? So at least then you don't suffer the full brunt of an attack. So the starting point, of course, apart from introducing third parties to protect your asset, is your relationships with everyone else in your business. In the event there's an attack, how is that affected? And is that built into your contract? That's certainly something that everyone should think about and incorporate in their contracts.
Yeah, and I think on that, just to add on as well, I mean, we're talking about frauds here, but I mean, also the contracts are also important in the sense that you want to be clear, or you want to have some clarity in terms of how your assets are actually being held by the third parties. Are they allowed to trade on your behalf? Are they commingling your assets with others, or is it held in separate accounts? Is it a segregated wallet or account and stuff like that? Because that would affect the legal categorization in the event that any asset tracing efforts, or even where touch wood, there's some sort of insolvency event, right? Are you going to end up being just a general class of creditors, in which case there could be millions, right, of people who are in the same position as you? Or do you want to make sure that you're elevated to that of maybe having some sort of proprietary interest, i.e. Its assets are held on trust for you, so it's some sort of property rights to it. So that is also important, and that I think ties in with what Kumar is saying about pay attention to your contracts in the first instance, because that's really the first port of call in terms of how risk is allocated between the parties.
I'd like to kind of to keep it in a positive tone as well, and to think of the goods and the uplifting side of things rather than the threats. Any good positive examples of recovery or prevention, case studies or examples that you could share on a no-name basis that would give people a positive view on what's possible in this space, that they shouldn't just throw up their hands? I sometimes worry that the threat actors have been emboldened by a sort of an attitude that nothing can be done, the police won't do anything, the courts won't act for you. It's all on the investors' risk on their shoulders, and that they're powerless when something happens. But I'm sure that's not the case from the conversation today. So let's spread the word on what is possible and the good outcomes that can result from that.
Absolutely. I mean, two come to mind, right? The first is last year at Token 2049. There was a impersonation scam. So someone impersonated an event. They got people to sign up, and it looked legitimate, because you get emails from. So you cannot detect that it's a scam because it's from a legitimate source. And so there were victims who went up, got prompts from the threat actor saying, you need to mint an NFT, if not, you'll be turned away at the door. Right, 1 hour away before the event, right? So there's this false sense of urgency. You want to attend the event. All these good people are there. So there was one particular victim who connected the wallet, minted an NFT, and it was a cold wallet, and he was prompted to enable blind signing on the wallet. What this means is that if you enable blind signing, you cannot see all of the transaction. You can't see the endpoint, but you enable it anywhere. You enable it anyway. And so blind signing is actually a common, not common, but a known vulnerability in cold wallets. So you might think that your assets are safe, but if you're tricked into blind signing, you're not. Right, so this happened. You tricked into blind signing, wallets drained, a couple of million tokens lost. right, for particular project. We managed to get it back because the victim had a good relationship with the asset issuer. So within the span of about 20 minutes, a decision was put to the DAO on whether or not to initiate a burn on the tokens, and the tokens were burnt. And then we entered into a conversation over a few months actually on whether or not the issuer could give it back, and ultimately the issuer gave it back. Right, which is why both Amelia and I think, are saying this must be the starting point. Burn it and reissuance must be starting point. There must be laws for it. That's the first clear instance. The second one, it's a matter that both Michael and I actually worked on recently. We had a crypto trader who got a prompt on his phone saying someone is trying to log in from the Netherlands. Right, he went to change his email password, both on his personal email and the one associated with an exchange, because he had assets parked on an exchange, very large exchange. He thought everything was safe. Once you change your password, there's a 24-hour halt on withdrawals. So you think, oh, no one can withdraw your assets. So you go to sleep. He went to sleep. He woke up, about 3 to 4 million USD gone from his wallet. And it turns out the manner in which his exchange accounts were compromised were that the hacker used 3 other accounts on the exchange, entered into trades, right, on both sides of the transaction, and siphoned monies out that way. So in this case, the exchange had a part to play, unfortunately, in how this victim lost his assets. But the problem is that, when you sign up for an account on an exchange, the entire terms and conditions are stacked against you. There are risk disclosures. You're responsible for all of your trades, etc. But these particular terms and conditions were governed by Hong Kong law, and in Hong Kong, there's a statute. I mean, this is not legal advice, of course. I'm not qualified to advise on Hong Kong law, but there is a statute called the Hong Kong Unconscionable Contracts Ordinance, which states that, in certain instances, if it's so unconscionable or unfair, the court can rewrite the contract or rewrite parts of it. So we basically put up a claims notice. We didn't have to send it in the end, but we put it up anyway, right? That this is a textbook example of a contract that's so unconscionable and unfair. It surely amounts to the level you need to rewrite certain parts of it, right? And once you rewrite that, then there's case law, Canadian case law, right? There's no case law in Singapore or Hong Kong to my knowledge, but I've used Canadian case law in the past successfully to allocate risk. So if some other counterparty systems are compromised and that led to the loss, then you should bear a part of the loss. So right, once you get rid of that uphill battle, you can imply terms into the contract to shift liability to the exchange, right? That's one big part of it. The second one is, and I've talked about this earlier, how did the threat actor know to target this exchange or this email? And we went with a data breach on the end of the exchange because there was enough noise in the industry about a potential data breach. And so our client, in an amicable manner, made all these points to the exchange, right? Like, look, this happened. This loss wouldn't have happened, but for your accounts being compromised, there may have been a data breach. If necessary, I'll have no choice but to pursue that. And there was a third point as well, which is that this exchange had a FinCEN consent order in the US, which obliged them to put a monitor in for 5 years to monitor their systems, their transaction monitoring system. So we said, I'm sure the monitor would like to know why it is that 3 other accounts are compromised. How are they compromised that led to this, right? So we had a big enough stick, but we also had a carrot as well. And the carrot in this case was the fact that our client wanted to continue holding his assets with the exchange. So both sort of all these factors together led to about 30 to 40% back without having to resort to legal proceedings, right? So I think, that's a matter that Michael and I were fortunate enough to sort of put together and work with. And it's not everything, but it's something. It's definitely something, yeah.
Yeah, I would like to add, and Amelia could chip in, but I think we talked a bit about the legal side of things. So I think in terms of the more positive aspect, is actually on the technical side of things as well. While just now we heard about blindsiding, like I said, there is a danger if you don't know what you're dealing with when it comes to technology, especially dealing with crypto asset. But there is also the upside, right? Because there's a lot more control. Because if you know the technology, you know it inside out, you can really there's a lot more control than your traditional trusting the financial institution, right? Because there's not a lot of transparency of what goes on in the financial institution, and for good reason, right? Because it's regulated. But on the technology side, like what Kumar said, we are able to find out on what has happened, how it happened, because there's a lot of transparency on the blockchain, So if you know how to access this information, it can be used on a very positive note in terms of recovering your lost asset as well, by a third party. So we're not a bank, but we can find the information because it's on the blockchain, most of it, right?
Interesting. So the technology can be used for defense as well as used against you.
Exactly. And it's a lot more transparent.
Amelia?
Yeah, I mean, I think Kumar and Michael has touched on a couple of examples, and I think what I wanted to share is also don't think that just because hackers are anonymous on the blockchain, there's no way you could actually try to trace or get information or get KYC information, like what Michael said, because there are actually digital footprints that you can obtain. And in fact, I think there's one BVI case a couple of years ago called Chain Swap, where injunction was obtained against persons unknown, and they ultimately, there were hackers that hacked onto a sort of a blockchain system where crypto assets were diverted to other accounts and then ultimately misapplied for other purposes. And the end wallet where these misappropriated crypto assets were held in was, with the assistance of some forensic folks, they could trace it to a wallet in Croatia, and therefore they could obtain a letter of request to the courts in Croatia to ask for information about the holders of these wallets, etc. So there are things that you can do in terms of getting information about these third parties, and issuing mechanisms such like knowledge farmacle orders, bankers trust orders to trace, where the assets have gone, and to at least obtain some recoveries, or at least make sure that there's no further loss caused to your wallets in your account.
Thank you, Amelia. Well, I know that for our clients and the people that we advise, this can be a scary and unfamiliar space. But today, I think we shared some positivity and hope and encouragement that there are options, and actually that the technology, the laws, the processes can be used in your favor, and it's not as a lonely or challenging space as you might think. But of course, the advice is get in touch with the experts and the specialists as soon as possible, and to leverage that experience. And there are good examples and good recovery that can come from that. Just leave it open for any final comments or thoughts from anyone here, if there are any.
Yeah, I've got one. I mean, I'm on this pet mission to sort of build systems that would impose liability on intermediaries, right? Because I do think that they profit a lot from all of these scams and hacks and transaction fees, but no one talks about it. But so, in my view, there should be a system where, in the event there's a compromised wallet, all these intermediaries are notified. They are put on notice. This state of knowledge is the first step, right? That the law that the law requires for you to possibly say, hey, you should also be responsible for the hack and the fact that you're in receipt of misappropriated funds. So broadly speaking, there are two ways to go after, not go after, but two instances where intermediaries may find themselves liable. Right. The first is knowing receipt. If you knowingly receive stolen property, then you should give it back. Right? And the law recognizes that. It's as simple as that. The second broad cause of action, so to speak, is called dishonest assistance. So maybe you don't receive the asset, but you helped. You helped in the compromise. Maybe you're an operating company of a mixer. Maybe you retain some control over those switches and handles. If you're put on notice, then the law does impose an obligation. It may impose an obligation for these intermediaries to also say, hey, you should be liable to these victims. Because if you didn't assist them, then they wouldn't have gone through. So that's this idea of notifying everyone of compromised wallets is something that we need to build. I think that there are already platforms out there where victims can go and report their compromised wallet. But then the next step would be naturally to notify everyone, right? We even had one particular instance where we could have mounted a case for knowing receipt of an exchange on an exchange, because right before the assets moved, it was flagged as a scam related wallet, but it still went through. And I know from conversations with GMs of the exchanges here in Singapore that their transaction monitoring systems should stop. The systems are designed to stop all of these things, you see. So, in summary, first we need that notice mechanism so that all these third parties are put on notice. Second, we need that burn and reissue remedy. So those two things combined freeze the movement of assets on chain, and you crowd them out to these third party intermediaries and you catch them there, right? And the intermediaries themselves might become a target. So, I mean, those are my thoughts on how we could improve the current state of play to help victims get recovery.
Very interesting, Kumar, and using the transparency of the blockchain in our favor, and making sure that accountability means that people play their part. I hope your mission is successful. You did mention burn and reissue many times, and Amelia, seemed to be optimistic about that. Is that a practical option for only a subset of digital assets, or for our listeners, what kind of digital assets can you can't obviously look to a large cryptocurrency and ask them to burn and reissue, right? You're talking about smaller projects, or what's the right way to understand that as a possibility?
Not necessarily, but I'll let Amelia take this question.
Yeah, I mean, I think it's a very practical question, and it really depends on the issuers, the developers, because to what extent they are willing to help. And of course, if we talk about a large sum, then query they whether or not they would be keen in doing that. I mean, the cases that we've seen in the past are all relatively smaller amounts. That said, I don't see a real distinction as to, I don't see a principled sort of distinction between why they could do it for a small sum and not a large sum. But I don't think there are any clear framework governing that. So which is why I think I go back to Kumar's point about allocating risk in the first instance in contracts, because if you can ask them to include that as a potential remedy, then why not?
Yeah. Okay.
Absolutely, Emilia. That has to be the starting point now. Putting it into the contracts.
Important to consider what you're signing, what you're agreeing to, and to protect yourself on these considerations up at the beginning of the relationship rather than after the fact. But I've taken up a lot of everyone's time. I really, really appreciate the fascinating discussion we've had here. Hopefully an uplifting and positive message for those who might be worried or are impacted by these topics. Really appreciate everybody's expertise and contributions. So thank you so much, Amelia, Kumar, Michael. I really appreciate you joining the session. As I've shared earlier, we'll be back in touch with edits and letting you review those before they're shared, and welcome your thoughts or any adjustments you'd like us to make. Really appreciate your time. Just to remind you again, when we finish the call, please just let your browser window or your page stay open until you see that the Riverside screen tells you that you've been fully uploaded, and that'll help us get the best quality for this session. So thank you so much again, everybody. Really appreciate your time.
Thanks so much, guys. Really appreciate the time as well.
Thanks, everyone. Yeah.
Thank you.
You too.
Thanks. Have a good week.
Bye.
Bye.
Okay, bye. Bye-bye.
Thank you.